I mean, do you see a consistent pattern though? When you get in trouble, it's always inebriation of some sort, of a controlled substance or alcohol, and that, but you're fine otherwise. It's just, and you know, it can lead to that. Larry Johnson, talk to him about being ready for this.
He's point 233 on that.
It was not. We now call cause number 19-33338. The state of Texas versus Larry Gene, thank you, Johnson Jr. That is you. Your attorney, Mr. Kimler, and the state's attorneys are present. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation filed on January 9th of this year? Can we proceed in Senate?
He does. We
Wow. And Mr. Johnson, you've had a chance to discuss this with Mr. Kimler. You understand what you're charged with here?
Yes.
Okay. Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Lawyer. In summary, sir, this motion to revoke unadjudicated probation states that on June 20th, that's a special day for me, by the way.
What is that, Sean?
Yeah, 2022. You were placed on 10 years deferred or unadjudicated probation for the second degree felony of aggravated assault. Is all of that true and correct?
Yes.
It's a special day for me every year on that day.
My birthday is 22nd, so.
Gee,
Yes.
I may change my birthday, you know that. Actually, we're opposite sides. The first day of summer is the 21st.
Right.
Well, mine was the day before and this was bad.
Yeah.
So I'm just 2 days older than you. What?
Sorry.
I heard that.
Do we need to call EMS?
Yeah, I think she's gagging. Back to this, which is not to make light of this, but it's unusual that because our birth dates are close by, we always make a deal about it when that date comes up. Do you understand, though, the seriousness of this case that we placed you on probation for in the first place, sir?
Yes.
And just to, I know you don't have to be reminded because I know you're a smart guy. You are. And I'm just very disappointed that we're back because I felt good about you fixing this mess and moving on. But this was the indictment pleaded that you intentionally and knowingly and recklessly caused serious bodily injury to another by cutting and stabbing that other person, which was an event that was capable of causing serious bodily injury or death, which is why it's treated seriously as a second degree felony, aggravated assault. Okay. Number one states you committed the offense of driving while intoxicated on or about December 26th, the day after Christmas, 2025, in Jefferson County, Texas, in violation of condition 1 of your deferred or unadjudicated probation order. Is that true or untrue?
It was true.
What happened in that case? Was there a misdemeanor case filed out of that?
There is, Judge.
What's the status of it right now?
It's relatively new, Judge.
Go ahead, Mike.
I'm sorry, man.
Everything would be enhanced. This is a point 223, so it'll be a class A.
Let's say is correct.
Okay. Are you pleading true to allegation 1 voluntarily and because it is true as it is alleged?
Yes.
Do you understand that a true and correct pleading of true to one or more violations of probation, that is enough to grant a motion to revoke probation by a preponderance of the evidence or greater. Your probation can be revoked. You can now be found guilty and sentenced to the second degree felony of no less than 2 nor more than 20 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes.
I find you are pleading true voluntarily. You understand and appreciate the consequences of truth.
They said, must stay okay. So, say, 4%. Starting with the first period,
Looks like all of this is, all these allegations are derived from that event.
That's correct, Judge.
So number 4 goes on to state you were at a location other than your residence at approximately 10:52 p.m. on or about December 26, 2025. That's important, correct? Because your probation order states you have to be in by 10 o'clock p.m. Is that right? Yeah, be inside your home between 10 p.m. and 6 a.m. That's your curfew. Is that allegation true and correct as it is alleged?
Yes.
And are you pleading true and correct to that voluntarily and because it is true?
Yes.
All right, there is no agreement here. Okay, may I see a few cents for you? Thank you very much. What took you so long?
I don't know. I was a little slow today, Judge.
Very good indeed. So it looks like on your felony court history, you were placed on probation back in 2004 for illegal possession of a controlled substance, for a 2-year state jail, suspended for 4 years. That was revoked in 2009. And you were sentenced to 8 months in the state jail. Is that true?
Yes.
Okay. Then there looks like another, that's odd. On 3/23/2009, you also received a sentence of 6 months confinement in the state jail for illegal possession of marijuana. So is that true?
Yes.
Okay.
Wait a minute ago.
Okay, that's your 2 felony convictions.
Yes.
That's all you have, right?
Yes.
And then the misdemeanors, possession of marijuana in 04 again, possession of marijuana in 13. Marijuana was kind of getting you in trouble in the misdemeanors. And on Mr. Johnson's time accrued here, can you help me on that?
Yes.
Okay, so we're looking at no less than 2 nor more than 20 years confinement in prison. On this DWI, the probable cause thing, I see what the circumstances are. Then there it is. Oh, 0.223.
Mr. Harris showed me the lab report.
But it actually matches the portable breath test you're reading in the phone calls, right?
On this, let me see. The aggravated assault. Okay, the complainant in that aggravated assault that you placed on probation, he was an ex-relative of yours? It says ex-brother-in-law?
Yeah, my kid's brother.
Well, that's hard to follow, isn't it?
The what?
Your
My
children's,
kid's brother.
Well, what?
oh, that's your,
What is it? Is
your
it?
brother-in-law.
Well, if they had been married,
We wasn't married, now we weren't even together. So,
there was no.
Oh, if you were married, it would have been a brother-in-law. Okay, it was a quasi brother-in-law, I guess.
Pseudo brother-in-law,
Can you even spell pseudo?
PSEUDO.
Very good.
I didn't hear you pronounce a P in that word. So y'all weren't common law married?
no,
Okay. That would have been a brother-in-law then,
yeah.
if y'all put that, okay. Hmm. All right, well, this looks like the end of the day, but there was some intoxication going on behind this aggravated assault
So,
of some sort.
yeah.
Barbecue at what's south.
Yeah, someone that told me they were good.
They've been putting some herbs and spices on the barbecue that this shouldn't have been. If you know what I mean.
The situation now, alcohol tends to enhance.
All right.
food.
Yeah. Okay, what did the party say?
All right, obviously, Mr. Johnson would beseech the court to continue his probation. I'm sure the state has other opinions, but I'll defer to Mr. Johnson to explain before his actions on the occasion question. Do you want to tell the judge what happened?
Yeah, I know I did two things wrong. I made a mistake. I left. I shouldn't have been out that time night. And I was drinking. But two mistakes I know I made. I just want to do right by her, make up for my mistakes, do right by her. Seems like I ain't be getting no trouble doing nothing. I just happened that night I did that.
What were the circumstances of you drinking? No,
I had nothing. I went to a class meeting.
no one got stabbed. Huh?
No, I'm glad I stayed.
On that occasion,
I went to a class meeting. I probably seen it's my first class meeting. I ain't never been on this. 25 years ago.
I mean, do you see a consistent pattern though? When you get in trouble, it's always inebriation of some sort, of a controlled substance or alcohol, and that, but you're fine otherwise. It's just, and you know, it can lead to that. But you gotta, I mean, you gotta be sensitive about, you've got a history, this seems to be the cause, but it's also your choice you're making. But that's a choice you need to change because it puts you in harm's way.
Poor judgment.
Stay.
All right, so on the positive side, Mr. Johnson made a good 3.5 years before he ran into this issue. Today, he's accepted his responsibility about the DWI. That's another positive for him. What's yeah, just I thought to myself when you made the comment that we wouldn't see him again, I was hopeful too, Judge. I mean, he hadn't been in trouble since 2009, which was part of the reason why I gave him the opportunity to successfully complete this probation. And I was hopeful that he would pay his restitution and we wouldn't see Mr. Johnson again. But here we are. And my knee-jerk reaction on aggravated assaults is that it's prison time is the best reaction. In the event that the court is not considering that, I would ask that whatever we do, that it be a strict message that comes to him. Someone who ends up with a 3 times the legal limit of a DWI while they're on probation is very telling. And to me, the only way that he stays on probation is if he goes to safety. Of course, I always defer to your honor. I will tell you that when I considered the amount of pen time, I made the offer to the defense of 7 years. So
Go ahead, from the defense.
I prefer to let Mr. Johnson, I think, has all what it needs before to make a decision. Obviously, he's maintained employment. He's done the other things on probation he's supposed to do. I appreciate Mr. Ham's arguing about the substance abuse issue. And I'll just defer to the court if the court continues, ask the court to continue on probation with whatever sanction. You do have the available upfront time. He also can revoke the deferred status. He doesn't have a TDC conviction.
I don't think it, no, we can't.
Oh, well, that's true, but you can't put it on straight.
Aggravated, there's a deadly weapon.
So you'd have to continue on the deferred. You do have available the upfront time section, but.
And from the probation office, I always appreciate your input.
Yes, sir. So it just seems like there's a substance abuse
Yeah.
issue that needs to be addressed. He also tested positive for alcohol on December 17th as well in my office. And I believe he told me that he got in an argument with his sister or something was going on during that time. And he had one twisted teeth on that date.
Oh. Anything else?
We rest.
Sir, anything you'd like to add before I make the decision?
I just give me a chance to do right. No, that's not anything.
I did. I mean, it would have put you on probation.
That was the first, I got on probation.
I know, but you've got 5 prior convictions. You've got
Those are old.
three misdemeanor convictions, substance abuse, all based on substance abuse, except the tampering with government records there. And then possession of a controlled substance that we placed you on probation in 04, and that was revoked in 09, and 8 months. Then possession of marijuana again, six months, state jail in 09. And then here you are, and it's inebriation of a sort, whether it's alcohol or drugs, it's still dangerous. And it causes you to make errors, which has been consistent, but you've been put in prison facilities before, and that would have, I would think that would change me, certainly. But you've done it 5 different times.
Ain't messing no drugs no more.
It's still, you're here. And not following the rules, and it's an intoxication again. You're not thinking sober thoughts.
Laid out their
You're
time.
acting it out. If nothing further, I'm going to find that there is sufficient evidence supporting this motion to revoke unadjudicated probation, to grant it by a preponderance of the evidence or greater, as allegations 1 and 4 have been proven true by preponderance of the evidence or greater, by beyond a reasonable doubt in driving while intoxicated, and you were at a location other than your residence at the curfew on that December 26th day. And that is enough to grant this motion to revoke unadjudicated probation. And your deferred or unadjudicated probation is hereby revoked. Earlier, in this case, you had pleaded guilty to aggravated assault, 2nd-degree felony, voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in that hearing to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of that aggravated assault, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. You will,
Three.
you will be given credit for all time you have served. Also, the judgment shall reflect that a sharp a sharp object, a deadly weapon, namely a sharp object, as it is stated in the indictment, was used in the commission of this offense. And the indictment goes on to allege that you pleaded guilty to, that sharp object in the manner of its use and intended use was capable of causing serious bodily injury or death, which is the definition of a deadly weapon. So that's going to be placed in there. The state had asked for 7,
Yes, sir.
and you were looking at 20, up to 20.
What was the back time period you're on from here?
It's more, not much, 28.
Less.
And
The PSI.
got it.
Thank
Yes,
you,
sir.
Judge.
Do you understand what has happened today, sir?
Yeah, so I'm sorry, 3 years.
Yes, sir. You're gonna get all time that you've been credited for, and hopefully this will pass and you can move on.